In terms of the negligent hiring specific to Doloff, I do want to point out that the only evidence in the record is that Mr. Doloff performed 39 prior security details with no injuries, no incidents, no issues of any kind. So that's the evidence in the record, and that's why the negligent hiring or attention claim specifically fails. In terms of negligent supervision, Western Stock versus Savit provides that there's no duty to supervise an independent contractor where the independent contractor retains the exclusive control over the manner in performing the work. Here, again, 9 News hired Pinkerton. There's no evidence of control of Pinkerton by 9 News. That's best demonstrated through the independent contractor agreement between 9 News and Pinkerton.
Counsel, I have a question. We have the agreement here between Pinkerton and the vendor, who was Iceborne. And paragraph 24 says that the vendor shall disclose to Pinkerton in writing the identity and qualifications of the same. How does that play into your argument? And would 9 News' relationship with Pinkerton then also require it to at least have inquired about this information?
Sure. No. The short answer, Your Honor, would be no, because of the independent contractor agreements. If the court were to collapse all those, you essentially destroy the reason for independent contractor agreements. And I think the Newman affidavit supports this the best, because Mr. Newman clearly states that 9 News does not have the expertise to provide security, which is why they hired Pinkerton, the world leader in security services. So in my mind, that agreement certainly doesn't change anything with respect to 9 News. It may affect Pinkerton, sure, but 9 News had no control of Pinkerton whatsoever. In terms of control, Your Honor, and with respect to if the court were to collapse all those agreements and consider whether 9 News negligently supervised Mr. Doloff, again, there's a lack of evidence as to control by 9 News. First is Mr. Newman's affidavit, where he clearly states that he did not control the actions of Mr. Doloff. And second, there's the 2 videos, Exhibits 5 and 12, of Wright's response to the motion to dismiss. And those videos make it quite clear that Mr. Newman doesn't provide any sort of direction to Mr. Doloff at all. There's no statements made by Mr. Newman. There's no help, intervene, nothing. Mr. Newman is simultaneously filming the incident between Mr. Keltner and Mr. Elliott. Mr. Keltner then approaches Mr. Newman, and Mr. Doloff then exercises his independent judgment and steps in without any control by 9 News whatsoever. Frankly, there wasn't even time for Mr. Newman to really give any sort of direction. So based on those videos and Mr. Newman's affidavit specifically, the negligent supervision claim would fail as well. In turning to the 6th claim for vicarious liability specifically, under Powell, security is not inherently dangerous. Security services actually decrease danger. That's why the district court in Powell observed that calling security services inherently dangerous is ironic. This is also confirmed in Mr. Isborne's affidavit, where he states the ultimate goal of his company to provide security services are to prevent harm.
Ms. Cleet, under the Huddleston case, isn't it necessary for us to consider not only whether security is inherently dangerous, but whether it was dangerous in these particular circumstances?
You are under elements 1 and 3, Your Honor, but the key, you still have to prove that second element of Huddleston, which is whether the activity is different in kind than what is normally encountered by persons in everyday community. And frankly, in the era that we're in, security is common. In order to get to this argument today, I went through security. When I left my office building to get here, I walked by security.
But counsel, isn't there a qualitative difference between the presence of security at the supermarket or at a movie theater, as you point out, or an office, or even in a courtroom? versus what was anticipated at this particular event. These are two countervailing perspectives. There was a history of violence across the country, not necessarily with these individuals directly, but with these organizations when in confrontation, and that was the very purpose. So doesn't that suggest that this was not something in the ordinary everyday experience?
In my opinion, Your Honor, no, because I think when you start to get into that, it's sort of a slippery slope of blending elements 1 and 3 into 2, and that's not the purpose of Huddleston. You still have to get all 3 of those separate and apart from each other. So 1 and 3, you can consider, the particular circumstances, but the second element is truly focused on the activity, not the circumstances, the activity itself, security services, and whether those are inherently dangerous. And there's no evidence that security is an uncommon danger. So in that respect, Your Honor, the vicarious liability claim fails.
Counsel, assuming that all of the first 3 Huddleston factors are met, what's your position about the exception that Huddleston articulated, and do you think you would fall under that exception? Which is the employer will not be liable for injuries caused by the collateral negligence of its independent contractor.
If all 3, you're saying, Your Honor, if all 3,
yes.
you're assuming
It's
all 3 are met.
inherently dangerous, and we decide this is inherently dangerous, do you still win under the exception?
I think we do, Your Honor, particularly because the connection between 9 News and Mr. Doloff is so attenuated. The best comparison is the Powell case, where in Powell, it was Rocky Mountain Planned Parenthood directly hired the independent contractor, but since this is so attenuated and there's so many levels of agreements, I do think that would not have, the 3 elements being met, I still think that the 6th claim fails. I would like to reserve the rest of my time for rebuttal.
Thank you, counsel.
Thank
You may
you.
do so.
Good morning, Your Honors. Todd Drake, attorney registration number 27258 on behalf of the appellee, Mr. Wright. Your Honors, this is not a case of a failure to produce evidence as suggested by 9 News. There is evidence in this record produced by Mr. Wright, produced by the other defendants in the case, affidavits, videos, photos, contracts, documentation as to Mr. Doloff's, the request for Mr. Doloff made by 9 News for a security guard, the qualifications of Mr. Doloff, all that is evidence within the record. To your point, Judge Taubman, yes, the court may consider the allegations. In fact, it is required to, under the statute, consider the allegations of the pleadings. When those allegations are supported in any way by evidence, they then must be accepted as true. That's what Coomer says. It's not that we accept the allegation itself as true. It's not just a pleading. It's not just a complaint. Once in this case, Mr. Wright, once the plaintiff comes forward with evidence supporting any of that, that evidence then must be considered as true. So,
Mr. Drake, then how does the court weigh, on the one hand, the allegations of the complaint that Mr. Doloff was not licensed, and on the other hand, evidence that he had been hired 39 times by Pinkerton?
2 issues on that, Your Honor. First of all, the court is not supposed to weigh that evidence. That's the whole point. 9 News argues that this court, if there's conflicting evidence, that this court and the district court should be weighing that evidence to determine whether or not Mr. Wright is likely to prevail. The case law is adamant, is settled on this. That is not the court's role. This court does not sit as a preliminary jury or in any way try and assess the strength of Mr. Wright's allegations or whether or not he will actually prevail at trial.
But counsel, can't we accept the fact that we don't know what those prior 39 times involved? And it was Denver that had the requirement, the regulation that of licensing and whatever in order to provide security within the city and county of Denver. So those 2 things might be completely unrelated, right?
I don't believe they are completely unrelated. And as to your first point, Your Honor, we do know what Mr. Doloff did on those prior occasions. It's in the record. I'm happy to find the site for it again, but it talked about his different. It was submitted as part of Isborne's motion to dismiss. It showed all his different times he had served as security. Notably in that, only once in all those prior times, the 30 plus prior times, had he done what he was doing on this day, which was executive and staff protection. All the other times were crowd control, were kind of your point, Judge Schutz. There is a qualitative difference between a security guard, what Mr. Doloff did on those prior occasions, where he's just there essentially to help keep crowds in control. It's you know, the security guard downstairs, security guard at Target is there to make sure no one's stealing from the store. That's vastly different from what Mr. Doloff was hired to do here. He was specifically requested to be armed, to be plain clothes so that he could not be identified by the public. And he was there for one reason and one reason only, to protect 9 News producer. 9 News producer, Mr. Newman, said in his affidavit, I was scared. I was in fear for my own safety. There had been rallies throughout the country in which violence had occurred, in which journalists were being attacked. I needed somebody there to make sure that I was safe and to be armed to do that.
Can I take you back, Mr. Drake, to your initial sort of articulation of the standard and the interplay between what we sometimes called allegations, but more accurately in the statute, pleadings, and evidence. I want to be clear as to what you're articulating as the standard. Are you suggesting that once any evidence is introduced, then all of the allegations in the complaint become treated as evidence at that point? Or are you acknowledging that the evidence has to relate to particular allegations for us to accept those allegations?
I think that's a fair distinction, Judge Schutz. There has to be something beyond the mere allegation in the complaint. We acknowledge that. That's certainly what Coomer has held. I do think there's even an arguable split on that. Coomer is the most recent decision out of this court.
So let me take it one
yes,
step further.
yes.
Are you suggesting we can't consider the pleadings at all, or specific allegations, even though unsupported by evidence on that particular allegation, or if those allegations of the pleadings have not been either supported by the plaintiff or opposed by the defendant with specific evidence, that we can still consider the allegation?
You may still, in fact, under the statute, is required that the court consider the pleadings, consider the allegations. It is not to accept those allegations as true. It then looks to, that's essentially that next step. Is there anything within that record that supports essentially the inference that that allegation could be correct, that allegation could be proved at trial? That's really the analysis. It's not, has Mr. Wright proven that allegation now? Has he come forward with evidence? Because that's the nature of these cases is, of course, Mr. Wright doesn't have all the evidence now that he would have at trial. Of course, he hasn't had the right to do discovery. Discovery stayed the moment they filed their special motion to dismiss. Go ahead.
Mr. Drake, I want to follow up on my earlier question to you about when there's conflicting information,
Yes.
whether it's from the complaint on the one hand and an affidavit from the other side on the other hand. And you said, well, the court's role is not to weigh that information at all. So if that's the case, then it seems to me there would be no difference between a defendant submitting an affidavit and not submitting an affidavit, because you're suggesting that the court would have to just accept the allegations of the complaint. Is that your position, or is it something different?
The court can certainly take into mind all the evidence that's produced, but it is not the role to say, okay, I have conflicting evidence. On one side, I have evidence that, for example, to your question as to the licensure, there is evidence within this record. It's at page 369. It talks about Doloff's background check. It notes that he was not licensed, or at least there was no check of his license. They go through a background check, criminal background check, whether he had a concealed carry permit. There's a box there for, was he licensed? That box is not checked. that is evidence that at least is indicative that Mr. Doloff wasn't licensed. On the other hand, you have an affidavit from Isborn saying, well, but we do background checks, we do these things. To your point, they in nowhere in that affidavit say that Mr. Doloff is licensed. It's, as we sit here today, there's no evidence of him being licensed, so there's really not conflicting evidence. To the extent there would be conflicting evidence on that, no, that is my point. You cannot then try and assess, well, was he licensed or wasn't he? You have to, if there is evidence before the court in which it can be, the inference can be gained, that allegation can be proved at trial, that Mr. Doloff was not licensed, then no, that case must be, that issue must be resolved in favor of Mr. Wright.
Counsel, I have a question on that inference, because on your civil conspiracy claim, which the court rejected, we've got Newman's affidavit saying there was no conspiracy, there was no evidence of an agreement, basically, is what the court found. And Mr. Wright provided evidence in the record of these individuals together under a tree, pictures of the individuals together. Now, certainly, an inference is that they were conspiring, okay, that they were making an agreement. So what do we do with the affidavit saying there was no agreement versus a photograph from which you might have an inference that there was? What do we do with that?
What you do with that is exactly what I'm suggesting, Your Honor. You cannot accept Mr. Newman's affidavit or try and weigh that evidence, that, this allegation or the, I guess it's not allegation, the testimony of Mr. Newman against the evidence that supports the inference. This is the LSS case that Your Honor was involved in. That involved a wife and ex-husband arguing over whether or not their child had, or the husband had done improper activity with the child, and where the wife defamed him in reporting that. In that case, this court held, there were opposing affidavits in that case. You had the husband saying one thing and the wife saying the other. And in that case, while the husband's evidence was not particularly compelling, the words were it wasn't particularly compelling, this court literally said, we cannot consider the affidavit of the wife as conflicting evidence. It is not our role to try and weigh that and decide which one of these is true. That's a jury's role. That's the whole point of this, and that's exactly why, Your Honor, I believe it was error for the district court to dismiss that conspiracy portion of under the fifth under the direct negligence claim, that theory of liability. The court made clear in its order it was relying on that affidavit of Mr. Newman and his statements. I didn't know Mr. Elliott. I didn't conspire with him. I didn't do anything. That's improper for the court to do, particularly in light of, and it's more than just, 9 News suggests they're standing alone under a tree, or they're standing together under a tree, and we don't know that there's some agreement. We have in this case additional evidence in which Mr. Elliott, not once but twice, is telling third parties, he's going on interviews and saying, I am part of this team. This is our news organization. Where does that information come from? We don't dispute that, or at least under the evidence right now, there's nothing to suggest Mr. Elliott was an employee of 9 News, but he certainly thought he was part of this team. He thought he was part of what was going on that day with Mr. Elliott and Mr. Doloff, and said that twice. So where is that coming from? I believe that is indicia of some tacit agreement between these 3 individuals as to they were working together.
Mr. Drake, does that particular line of factual argument relate primarily to the negligent supervision aspect of your direct negligence claim, or more to the negligent gathering of news component of your direct negligence?
I think they're kind of consumed within each other. I do believe it falls primarily under the direct negligence claim, which I would articulate in the court. I'm sorry. Yes.
I apologize, but just want to be clear. They're both part of the direct negligence claim, as I understand it. So
exactly.
Under which aspect of the direct negligence claim is what I'm asking?
I suppose it's more under that theory of the news gathering. I think it's evidence the court can consider on all aspects of whether or not 9 News also was appropriate. And this is where I was going, not just in its supervision, but in its selection of Doloff, or in their view, just selection of Pinkerton, because that's really what the Western Stock, the CVIT case is talking about. It's not a negligent hiring case. It's negligent selection. And as 9 News concedes in its reply brief, there is a duty when retaining an independent contractor to explore that contractor's fitness and ability to operate safely. So that's the aspect of where it's going to. It I think applies to both, but it is more directly related to this concept of theory. And this is the only part of that claim that was dismissed by the court. So the claim still exists. It wasn't dismissed by the court. That theory was rejected by the court on the idea that they couldn't be negligent in their news gathering because essentially there was no agreement. He said, I find there's not enough context to establish an agreement. Again, no express agreement had to be required. And also essentially that it's not illegal to gather news, to record this. That's not our argument on that claim. It's not that they were gathering news. It's that they conspired to try and incite violence. They talked, in our view, and we believe the evidence establishes this and will establish it in trial. Mr. Newman, Mr. Elliott, Mr. Doloff met, they talked about it, and they said, we see you're out here trying to rile up people. We want to tape that. We want to record that. And let's follow you around, and you do that. You go up to people and do that. And Mr. Elliott agrees to do that, knowing that this is likely to incite violence. Mr. Newman went into this rally knowing it was likely to be violent. He was there for one reason, was to try and record that violence. That's the problem. That's the conspiracy and the agreement by these individuals, at least some indicia of a tacit agreement between them that this was what they were going to try and do to achieve an illegal means. I'm happy to answer any other questions of the court. I do believe, Your Honors, I agree with 9 News that these are 2 separate claims, direct negligence, vicarious liability. The direct negligence is under CVIT there. The negligent selection, I'd ask the court to look at the record, page 380. 9 News suggests Pinkerton's essentially the one who's hiring Doloff. Look at that. It says it's Pinkerton's, note or email to Isborne Security. It says this is on behalf of 9 News. The client is identified as 9 News. This is 9 News request. This is 9 News saying we want an armed, plainclothes security guard there to defend our person. The trial court said, I infer from that this was 9 News request. That under CVIT is enough. That goes to the issue on the duty of negligent selection. Thank you, Your Honors.
Thank you, counsel.
Your Honors, I want to start with conspiracy since I didn't get into that on the opening. Specifically, I want to talk about inferences versus Mr. Newman's affidavit, because paragraph of 55 of Rosenblum specifically says that the court won't infer an agreement. They need something more. The only evidence in the record as to conspiracy is that there were 3 people in the same place at the same time. That's it. No evidence of discussions, no evidence of anything other than those 3 under a tree. That's it. In terms of inferences that you can draw from the evidence, first, inferences don't have to be accepted as true because they're inferences. The evidence certainly has to be accepted as true, and any inferences that the court's going to draw needs to be reasonable. The only reasonable inference that even could be taken from, in my opinion, is that they were under the tree to maybe interview Mr. Elliott, sure, but a conspiracy is going quite far and quite an inferential leap. In terms of Mr. Drake's comments about Mr. Elliott saying it's our news organization, there's no conflicting evidence there. The evidence is that Mr. Elliott was not an employee of 9 News. There's 2 affidavits, one from Tegna, one from Multimedia Holdings, that Mr. Elliott was not an employee. Mr. Elliott even says in Exhibit 10 in that interview with 9 News, he says he denies ever associating himself with 9 News. And the reference to our news organization, certainly an inference can't be drawn there. For example, the Avs played last night. If I go into the office and say, we won last night, what a great game, we won in overtime, you can't take the inference that I am part of the Avs organization. I'm simply just a fan. So that's too far of an inferential leap to draw, and the only evidence is that they were in the same place at the same time. That's it. Thank you, Your Honors.
Thank you, counsel, for your very excellent and helpful arguments. The case will stand submitted and an opinion will issue in due course. We are going to take a brief recess to reconstitute the division for the next 3 arguments in the case. So the court will be in recess.
All rise. The court will be in recess.
Timothy Schutz. The next case on our docket is Foothills versus BOCC. I see both counsel are present. Were you here for my introductory spiel at the beginning at 9 o'clock?
Yes, we were.
Okay, all right. Were you also counsel? Oh, you were not. Okay, well, let me just, a few things. When you get up to the podium, if you could please enter your appearance first. The time will not start running until after you've done that. There is a toggle switch on the lower right side of the podium that you can use to raise and lower it. And everyone will be responsible for keeping track of their own time. And there are little lights up there that will tell you when the yellow light comes on, you've got 5 minutes left. If you have an electronic device, counsel at counsel table can keep them on. Everybody else in the audience needs to actually turn off all electronic devices. This is a new Chief Justice directive. Also, if either counsel has a party that is present in the courtroom and you wish to have that party sit with you at counsel table, you can do that as well. Finally, we are live streaming these arguments, so if there's any information you want kept confidential, please keep that in mind during your argument. Does anyone have any questions? All right, then we are ready to proceed in Foothills versus BOCC, 23CA686. You may proceed.
Thank you, Your Honors. Paul Ruffine, appearing on behalf of the appellant, Foothills Park and Recreation District, registration number 19948. This is one of the more pure and straightforward cases of statutory construction that I've ever brought before this panel. There is little to no factual dispute between the parties. There has been high levels of professionalism and cordialness and civility between the parties. I think we're all just here to try and get it right, because where we disagree is on the interpretation of a statute. We agree as to what law applies. This panel should apply the plain meaning of the statute, given meaning to all of its provisions and attempting to avoid an absurd result. The Board of County Commissioners and the developer in this case believe that Foothills leads this panel towards an absurd result. Foothills could not disagree more. The only absurdity that could ever come into a play is by applying this statute to the case at hand, subsection 107 of the Special District Act. Foothills' position is that just simply does not apply. And there are multiple reasons why. And if we here today adhere to all of those reasons, no absurdity whatsoever could ever come into play. And the county's land development regulation 32F, as it's cited multiple times in the briefs, simply applies, and the subject property should be included within the Foothills boundaries.
How can that apply without also considering the statute? I don't see how you can implement one without considering the other. I don't see them as separate things. They're both related. And if, for instance, you are a special district that provides park and recreation services, and you have a development over here that already has a park and recreation special district, or several special districts providing those services. So if there's two, one that exists and one that wants to provide services, how does that land regulation consider that without also considering the statute? Especially under the rules of statutory interpretation, we have to consider everything as a whole and consider them harmoniously.
Sure. The county land development regulation was designed very much with Foothills in mind. Foothills and the county work cooperatively to deal with the peripheral developments that come around Foothills. Foothills is a very, very large regional park and recreation provider that gets burdened by these peripheral tangential developments. They come in, they inevitably use Foothills facilities, but if they're not part of Foothills, they don't contribute as taxpayers. That's what the regulation is designed to do. The state statute is designed for something else entirely.
Let's turn to subsection 3 of the statute. 3A says, for purposes of this subsection 3, overlapping special district means a new or existing special or metropolitan district located wholly or partly within an existing special or metropolitan district. And then B says that the overlapping special district may be authorized to provide the same service as the existing special or metropolitan district, that the overlapping special district overlaps or will overlap. This case involves 3 existing districts, correct?
I think there's probably more than that
Well,
now.
at least 3, but
There is Foothills, and then there's a cluster of Red Rocks Ranch districts.
And Red Rocks 1, 2, and 3 are all existing districts.
They are, yes.
And Foothills is seeking to expand to the territory of those existing districts, right?
I do take exception with the semantics there. I don't think Foothills is seeking to expand there. Foothills is seeking to bring in the Red Rocks property into the Foothills boundaries.
But there will be an overlap.
There will be an overlap, yes.
Why doesn't 3 apply then? Why doesn't 3A and 3B, why don't those 2 subsections apply?
Well, the first reason they don't apply is because in order to get to subsection 3, you have to first get through subsection 2.
Except that subsection 2 starts with, except as provided in subsection 3. So 2 says, or doesn't it say, if 3 applies, you don't even look at 2, you just look at 3.
I don't believe so. I believe that that exception allows, because the entirety of section 2 says a new metropolitan district providing the same services shall not be allowed.
But there's
shall
no
not
new
be
metropolitan
organized.
district here. No, these districts have all been previously organized.
Which is precisely why the statute does not apply. Because
But
107,
3 contemplates what happens when an existing district seems to expand, so its reach overlaps with that of other existing districts.
I believe the intent and the plain language of 107 is for different circumstances. Foothills, again, is a very large district, has encountered this subsection many, many times, where there's an infill metropolitan district. There's development that comes already within its boundaries. Foothills being the existing district, or an existing district that wants to expand its services. And if they want to enter into the park and recreation arena, they must ask Foothills permission. That's what the entirety of 107 states.
Counsel, is there any authority out there that makes the semantic distinction that you're making here? Is there a difference between Foothills expanding into or Foothills trying to bring an existing in? Because that's what you're saying, is that Foothills is trying to bring an existing in. You reject that you're expanding into an existing district. Is there any law or authority that makes that distinction?
There is not. That is overly helpful. Part 4 of the Special District Act deals specifically with inclusions and has some language as to what comes in versus expanding outward. But I think it really does boil down to a matter of statutory construction and specifically as to what is overlapping. If we get there, Foothills believes we should never get there. But if we get there to answering the question of who is overlapping who in this case, it's been made clear. The county admitted that it would be the Red Rocks Ranch districts overlapping Foothills. The developer in front of the county under oath said, yes, we will be the overlapping district. We are bringing them in to Foothills, therefore they would then overlap with Foothills. That's where the absurdity starts to come into play if you get down this road, because if you want to apply 3B Roman numeral 4 as to which district then ultimately needs to consent regarding the issue of same services, the application of this statute to this case results in Foothills consenting to Foothills' desired inclusion.
How do you read that? I mean, it strikes me that because Foothills is seeking to expand such that its reach overlaps that of the existing districts, the Red Rocks districts, then the Red Rocks districts are the districts that would have to provide the consent under 3A4 or 3B4.
That would be the case if Foothills were overlapping Red Rocks Ranch.
But that's what it's seeking to do here.
It is not. Foothills is seeking to have Red Rocks Ranch overlap Foothills.
Why does that make a difference? If there is an overlap, regardless of who's doing the overlapping, doesn't 3 apply?
Foothills' core position, to be very clear, is that it should not make a difference because the statute does not apply. If we are going to try to apply the statute, then it makes a critical difference. Ultimately, if we get down to, I believe we're at the 5th if-then statement as to whether this should apply or not. But if it does, then which district is overlapping which does matter. And because the county interpreted this, Foothills was aware of the issue in presenting arguments before the Board of County Commissioners, in drafting pleadings. There's a specific allegation in the complaint stating Red Rocks Ranch overlaps Foothills. Both then defendants admitted that it did.
Counsel,
Yes.
I take issue with the use of the word admission. It seems to me that in describing the situation, the use of the term overlap is the natural way to describe the coexistence between these two parties, regardless of who is viewed as the overlapping district for purposes of 3B. And it seems like you're trying to take the term overlap that was used in a sort of explanatory phase and treat it as a judicial admission in terms of what the statute means. And that seems like a reach.
Understood. I don't believe it's a reach simply because of the statute's use of the word. The statute's use of the word as a defined term, when Foothills put it in its complaint as an allegation and it was admitted, I think there was meaning to that. When the developer appeared before the Board of County Commissioners and clarified by stating Red Rocks Ranch would overlap Foothills, I believe there was meaning to that.
Where do we find the definition of overlap that we should apply in interpreting the statute? Do we look to the dictionary?
I think we start with the statute. I think 3A talks about a new or existing
But the
district.
statute doesn't contain a definition of overlap unless I missed it.
I think that's a starting point. I would agree. It defines overlapping special district to mean new or existing, located wholly or partly within an existing.
And I'm talking about the word overlap generally, not overlapping special district, the word overlap.
Sure. And I think in that case, we are left with simply the plain meaning of the word, which would be the dictionary definition of the word. And in this case, with this request, Foothills is seeking to have this property overlap with Foothills. That is what is being done here.
Let me ask you a question of the consequence of interpreting the statute the way that you are asking us to. If we conclude that 107 doesn't apply, then the only vehicle for inclusion is 401, right?
That would be the ultimate vehicle. It starts with Land Development Regulation 32F, where the county would obligate the district to seek inclusion, and then Article 4 would then apply.
So sounds like what you're arguing is that in order to get to an inclusion, the county would have the authority to require the district or the developer to consent to the inclusion of the property that's already within a district that's providing these services. And you would compel the developer to then file under 32.1.401, right?
Yes, that would be the case.
But doesn't 32.1.401 also provide that the grounds for inclusion shall not include grounds for grounds that could not be permitted under 32.1.107? Doesn't that 32.1.401 contain that provision? Unless the developer consents, or excuse me, the property owner consents. Do you know of which I'm referring to?
I do. In that particular case, the property owner consent would be presumed because the county would be obligating it to do so in order to get development.
Okay. But doesn't that end up putting the regulation in direct conflict with the statute? In other words, the regulation would give to the Board of County Commissioners the authority to require the developers to consent to an inclusion when 32.1.401 requires the developers to consent. In other words, it takes the consent that's required under 401 and makes it a mandatory condition that the Board of County Commissioners can impose contrary to 32-401.
I don't believe it's contrary. The county extracts any number of consents from a developer in order to get development approved. And the land development regulation specifically contemplates that this issue of inclusion needs to be resolved before final plat approval, along with setback requirements, drainage requirements, all types of things that ultimately the developer would consent to. Here, the developer would be consenting to the exclusion process. The overlap between the two, when we incorporate Article 4 of the Special District Act, would get down to essentially the quote-unquote same services discussion. And there, the land use regulation makes it clear that it is a qualitative analysis that should be done here. The simple fact that Red Rocks Ranch does provide park and recreation services is not dispositive, because it's a sufficiency argument.
Aren't those the same services? Aren't all the special districts here providing the same services, parks and recreation services?
If we look at that broad category, yes. But the land development regulation talks about sufficiency of services. And in its initial evaluation, the county found the very small park and recreation provision, the neighborhood services provided by this development, to be insufficient to provide for the regional needs. I've blown past my reserve time, which is fine because these questions inevitably would come up on rebuttal. I do want to reemphasize, we got down to maybe the third or fourth criteria here to determine whether the statute applies. I would encourage the court and the panel to look at the entirety of the arguments in the briefs, as I know you will, as to the inapplicability of the statute. Thank you very much.
Thank you, counsel.
May it please the court. My name is Jason Sorensen. I'm an assistant county attorney representing the Board of County Commissioners. And I do intend today to split at least some of my time with counsel for interveners, so I would like to attempt to reserve 5 minutes for their presentation.
Okay.
So the issue in this Rule 106 appeal is whether the board's denial of the inclusion request was an abuse of discretion. And ultimately, the focus, as counsel for Foothills discussed thoroughly, is the interpretation of 32-1107. It is not the interpretation of the county's local regulation. And I do just want to touch on a few of the points that were brought up in Mr. Rufian's arguments. So Foothills contends that there will be no absurdity if Section 107 is not applied, and only if the county's local regulation 32F is applied. But without those statutory protections that Section 107 offers, Foothills can essentially take over any other districts, such as the RRC districts in this case, and force their taxes and their tax base on the residents of that development. And I do also want to address this idea of overlapping, or the overlapping play on words, if you will. So Foothills has argued that the county admitted that the RRC districts are the one that is the overlapping districts, but as Judge Lipinski pointed out, it really does not matter. The fact is that they are overlapping. What the key distinction here is which district is already authorized to provide the service in the service area in question, and that is the RRC districts. There is no dispute that the RRC districts are the only district authorized to provide services in the area in question, and Foothills is not authorized to provide park and recreation services.
Is the Board of County Commissioners bound by its previous understanding and previous application of the term overlap?
Do you mean in the, I guess the idea that we admitted that one was overlapping the other? Is that
even if it's not an admission, is the county now changing its interpretation of the word overlap?
The county's not changing its interpretation of the word overlap. I think the party that's seeking to expand and overlap the existing district is the party here that is Foothills, and the existing district that provides that service needs to consent to that outside district coming in and overlapping and providing the same service. And if you do look at subsection C in Section 107, it's important to note that the statute seems to call out the intent of the purpose of Section 107, which is to discourage the duplication and overlap of services provided within a service area. And so I do just want to touch on some of the I guess, direct issues that we have here in this case. And the first is the applicability of Section 107. So subsection 2 of Section 107 states that unless certain conditions in subsection 3 are met, special districts cannot provide the same services in the same service area as another district. Again, there's no dispute that the Red Rocks Center metropolitan districts are authorized to provide services, including park and recreation services within this service area. Foothills is not authorized. So the practical effect here is that Foothills' request for inclusion would cause their boundaries to expand to an area not currently authorized, which is the RRC district. So they would need to get the consent from the RRC districts. And Foothills' argument that the words organized and organizing should mean that the statute only applies to the initial organization of a special district should not and cannot lead this court to reading the statute in isolation to suggest that it only applies to a new district. If you read the statute as a whole, it clearly concerns the location of the service area, not the organization. Part 3, I believe, of the Special District Act covers the organization of districts. And so when focusing on Section 107 as a whole, subsection 3A specifically defines an overlapping district as a new or existing special or metropolitan district located wholly or partly within an existing district. And that's the exact scenario that we have here.
Now, Foothills argues that Foothills and the existing Red Rocks districts don't provide the same service. Could you address that point? He says that the Red Rocks districts are proposing insufficient park and recreation services, and for that reason, they don't provide the same services as Foothills.
Sure. So it's the county's position that the proper interpretation of the statute is that service is the overarching category of service that a district or metropolitan district is authorized to provide. So Foothills' argument is we believe it's improper to focus on this comparison of the improvements or the facilities offered through that overarching category of service. And Foothills also includes this word sufficient that I believe comes from the county's local regulation. But before we can even get to the local regulation, we need to satisfy the statute here. And when it comes to this idea of same service, Foothills obviously is a much bigger, more established park and recreation district. But service is the statutory category of authorized service. It's not a qualitative analysis of the improvements or the facilities offered through that service. If you look elsewhere in the Special Districts Act, 32.1.103 subsection 10, it defines a metropolitan district as a special district that provides any two or more of the following services. And then it proceeds to list a number of services such as sanitation, mosquito control, fire protection, park and recreation, like we have here. So clearly there's this direct correlation here with the overarching category of service, and then the golf courses, parks, trails, bike trails, walking paths that are provided are the improvements or facilities through which that service is offered.
Mr. Sorensen, I'm sorry, go ahead. Okay. Just quickly, two quick questions. One, what's the proximity between the districts at the closest? It looks like the western boundary, basically. What's the proximity? Is a mile, less than a mile?
Do you mean the proximity between Foothills and the RRC districts?
Yes.
I'm not sure the exact proximity. Foothills is kind of scattered throughout the county, but I don't believe that they're all that close. I mean, they're certainly not adjacent to each other. So and I believe there was testimony even that the closer park and recreation facilities or improvements to this specific development would lead to the residents of this development using non-Foothills improvements, such as Bear Creek Lake Park, which is directly across the street from this development. Green Mountain is nearby, as well as Red Rocks.
So, but it seems like that invites us into a comparative analysis of the quantity of the facilities and the related benefits or services in the smallest sense that are provided under the broad category of services. And yet it seems like you're arguing that we should not get into that comparison.
I don't believe it's proper to get into that comparison. I think when the statute talks about providing the same service, that service is park and recreation service. How that service is provided is through various facilities or various amenities. But the idea of same service is the broader category of service as a whole, and that is just the service of park and recreation, which the RRC districts are authorized to provide in this service area in question.
Council, let's assume that we affirm and this development goes forward and they discover, oh my gosh, we are providing insufficient services. Is there anything that precludes the Red Rocks districts from then later going to Foothills and saying, hey, we're giving you consent to provide these additional services?
There's not. So this initial non-consent by the Red Rocks districts is not a permanent decision. So later on, if that indeed happened and the residents of this district decided that the services or the improvements were inadequate, they can either decide to finance additional facilities to kind of satisfy what they envision as being provided under the Park and Recreation service, or they can vote to include themselves within the Foothills district.
So the residents would then be the ones that would initiate any actions involving the more quantitative, specific services that are included in Parks and Recreation?
Correct. There can be a vote to include themselves into that district.
Doesn't that scenario, though, create a potential absurdity that it looks like 32F is designed to avoid? So it seems that 32F is concerned with the situation where another district, whether it's a metro district or a straight park and rec district, gobbles up the land and it's part of their tax base, but they're not providing the service. And these people end up going over into Foothills and using their services while not paying anything to use those services. So is there any way that Foothills can avoid that absurdity other than demanding inclusion of the new subdivision?
Sure. So there's various checks on, I guess, a district not providing or having a material deficiency in the services provided, and that is through the service plan that calls out the various services that are provided, as well as the platting process. So it's important to note that the plans for this particular development do have park and recreation improvements. Again, they're not as robust and as extensive as Foothills, but there's miles of trails, there's parks, there's bike paths, there's playgrounds. I believe there's even an amphitheater and a splash park provided or planned for this development, and that all is included in the record. And this idea that Foothills is, people can just use it for free is not true. Foothills testified that at many of these facilities, Foothills can and does charge more for out-of-district or non-Foothills residents to come and use those facilities. So Foothills certainly can make up any of that lost revenue by charging these individuals more. And I do just want to touch on this idea of consent quickly before my time runs up, and I do want to leave a few moments for counsel for interveners. But if you do look at subsection 3B4, it states that the Board of Directors of any special metropolitan district authorized to provide a service within the boundaries of that overlapping area must consent to the overlap. And so again, only the RRC districts are authorized within this service area. Foothills is not authorized, so the RRC district need to be the ones that consent to the Foothills overlapping. And Foothills' argument that it should be the one to consent to its own inclusion request is the absurd result that we're talking about. It's not logical, as any district seeking to expand would always approve its own request. So I do just want to leave a few moments here for the interveners. Thank you.
Thank you, counsel.
Good morning, Your Honors. May it please the court. My name is Courtney Shepard. I'm counsel for interveners Theraldson Ethanol Plant 1 LLC and Red Rock Center Metropolitan Districts numbers 1 and 2. I want to briefly touch on a few additional arguments that Foothills made in its briefs, even though they didn't have time to touch on those today. We request that this court affirm the district court's rulings on 3 additional issues. First, Foothills argued that the district court should have added documents to the record that were not before the board when the board decided Foothills' appeal. The district court correctly ruled that Rule 106 explicitly limits its review to the documents that were in the record before the decision maker when they made the decision. Second, Foothills argued that the district court should have granted its request for injunctive relief. Foothills is wrong because the district court properly determined that it could not grant Foothills a request for a permanent injunction because Foothills did not succeed on the merits. And therefore, the district court properly dismissed Foothills' request for permanent injunctive relief. And finally, Foothills argued that the district court should not have dismissed its declaratory judgment claim. Foothills is also wrong on that count because Foothills' declaratory judgment claim, as pled in its complaint, was duplicative of its Rule 106 claim. So once the district court had denied Foothills' Rule 106 claim, there was nothing left for the district court to do on its declaratory judgment claim.
Let me push back just a little bit on that.
Sure.
How about the argument being made by Foothills that this is not just a dispute between these two districts and Thurleson and Foothills, but that Foothills has this issue reoccurring around its boundaries. So why wouldn't a declaratory judgment be helpful or necessary, and why should we not enter a declaratory judgment?
That's an excellent question.
for-
Certainly. No, that's an excellent question. So the specific claims that Foothills has made in this case, we believe can be entirely resolved under the Rule 106 review. And the fact that this issue has replicated and it has occurred over and over again is certainly a factor, but Foothills didn't plead a specific declaratory judgment claim that, for example, challenged the overall validity of Section 107 or the overall validity of Local County Regulation 32F. Instead, they've just requested a determination of the rights and obligations of these parties with respect to this property. And the fact that the case has repeated itself is a fact that has happened, but they haven't changed their declaratory judgment claim, even though the case has basically repeated itself with different property. So I wanted to, So just briefly, a couple of additional points on these arguments. So first, Foothills' request to add documents to the record. We think that Rule 106 is clear as to what documents the reviewing court should be reviewing when it's looking at whether the reviewing body abused its discretion or exceeded its jurisdiction. Here, the court clearly made the right decision and only looked at the documents before the board. Again, Foothills was not entitled to permanent injunctive relief because it did not succeed on the merits, and we do believe the declaratory judgment claim was duplicative for the reasons I just stated. Thank you so much for your time today. We appreciate it.
Thank you to all counsel for your very helpful and excellent arguments. The case will stand submitted and an opinion will issue in due course. We will take the next case once counsel have had an opportunity to get set up at the table. All right, we will call the case of Milan v. Eubanks, 23CA1623. I see both counsel are present. Does either of you have any questions before we get started? No, no. All right, then, counsel for appellant, you can begin when you're ready.
Thank you. Good morning, Your Honors. I'm Isaiah Quigley, and I represent the appellant, Kelly Milan. The case before the court is one which scrutinizes the completeness of sellers' disclosures made in a residential real property transaction in Grand Junction, Colorado. Importantly, there are two standards that interplay with one another here. There is the general law and policy standard of Colorado, which binds sellers to disclose as to their actual knowledge. There is also the contractual standard, in this case, which extends that particular burden to disclose anything that, quote, ever existed. And that appears in the disclosure form. Plaintiff's intent was for this factual dispute as to the extent and propriety of the disclosures to be resolved by the jury. It was shortcutted by an order granting summary judgment. For purposes of this short discussion we have today, I want to present the two legal errors which are the pillars for our de novo review. And the first one is purely procedural. And it's tied to carrying out the accurate standard of review in a motion for summary judgment setting. The second is a legal and policy-based argument whereby the sellers are simply not being held to the standard of full and complete disclosure as required by Colorado law. And in turn, the burden was shifted on the buyer, Mr. Milan, to discover any and all defects or issues that had ever existed on the property. So as the court's well aware, procedurally, the non-movement is entitled to all favorable inferences, to the end of summary judgment being only viable in the clearest of cases. Moreover, several divisions of this court have made clear that motions for summary judgment and granting thereof is inappropriate when there's not a fully developed record.
But your client had the obligation to establish there was a dispute regarding material facts concerning what the Eubanks knew but failed to disclose. Mm-hmm. What evidence did your clients put forth, whether through affidavits or other admissible means, to establish that the Eubanks had material knowledge of the expansive soils that they failed to disclose?
Okay. So to answer this question, I want to make sure that the court's, again, in the context that there are two standards at issue. There's the standard of actual knowledge and the contractual standard of ever existing. But what was presented to the trial court was the affidavit of Mr. Milan, which disclosed his expectations and understandings of what the disclosures were. The disclosures themselves were disclosed. And then photographs.
But what evidence did your client put forward to show what the sellers knew but didn't disclose? So there's no strict liability here.
Sure.
The issue is, the key issue in the case is whether the Eubanks had material knowledge that they failed to disclose to your client.
Fair enough. So let's take the most glaring example that we've presented to this court and we presented to the trial court, which was the instance associated with the driveway. The driveway, we demonstrated a photograph that was taken in 2016, which showed the driveway as a complete pour, an ordinary driveway that you see on a day-to-day basis. And we compared that with a driveway photograph that was taken in 2018, which showed that it had been replaced with pavers.
Counsel, now, as I understand it, the Eubanks purchased the house in December of 2016.
Correct.
And you had a photograph from May of 2016.
That's accurate.
What evidence was there in the record to show what happened in between there? How do we know that this driveway wasn't replaced with pavers before the Eubanks purchased their house in December?
Well, I think first off, this is a circumstantial case. So there's circumstantial evidence to demonstrate that something happened between 2016 and 2018. And providing the benefit of all inferences to be drawn in favor of the non-movement, there is the ability to infer that it was done under their care and custody.
But the issue isn't what was done. The issue is what knowledge did the sellers have that they failed to disclose. So I want to go back to my previous question.
Right.
What evidence did you provide to the court to defeat the motion for summary judgment, establishing that the seller had material knowledge that the sellers didn't disclose to your client?
Again, the driveway is one clear example. There should have been inference drawn that the sellers did know about that. And in fact, there is no contrary evidence that was presented to the court. There is attorney argument that said, oh, this was done by the builder before sellers had that. Well, intrinsic in that analysis is the notion that they did know about it. They knew that it had taken place, whether that be from the third party of saying, builder saying, hey, I had to replace the driveway with these pavers, and here's the reason why. So in the context of a summary judgment setting, it was incumbent on the court to say, well, if the sellers knew or possibly knew, not
possibly knew. Are you saying you could defeat summary judgment by saying the sellers possibly may have known about certain conditions?
Your Honor, you've got to understand that this is incumbent on a mens rea analysis here. We're trying to get in the head of another party. So often when that's the case, and I've cited the case to the Agoro versus Colorado Common Corp decision, when you're trying to prove a mens rea component, it's almost impossible unless there's an outright admission. So what you have to do is rely on.
Couldn't you have asked the Eubanks whether they knew? You could have deposed them, right? The judge can consider affidavits, depositions on summary judgment and ask them what they knew, or have gotten affidavits from neighbors who might have seen when the construction occurred, or have inquired of the builder. Did you do this, or did it happen after you sold the house? I mean, aren't those all things that you could have done to establish knowledge of the Eubanks?
We definitely could have, and that was intended. We were in the infancy of the discovery phases of this case. It had not proceeded to the point whereby those had taken place yet.
Did you ask to pause the summary judgment proceedings until you could have a chance to take depositions?
We definitely could have, but I think with the...
But my question is, did you ask?
Oh, we did not, Your Honor, no. We didn't do the 56F proceeding to pause for depositions. What we did is we relied upon what the experts had discovered, which that there was a significant heat event that caused for the destruction and replacement of the driveway.
And you're talking about the Knott Laboratory report?
Yes, I am, Your Honor.
I've read this backwards and forwards. I don't see any reference in here to the seller's knowledge, because Knott had no idea what the sellers knew.
I don't think anybody does except for the Eubanks, Your Honor. So
Exactly.
unless I'm going to get them to admit it, we have to rely upon the circumstantial evidence. And to burden me with just saying, okay, just because the Eubanks are unwilling to admit.
But you don't know what they were unwilling to admit because you didn't take their depositions.
Not yet. I hadn't done it at that point yet.
But as Judge Schutt said, you had the right under Rule 56F to pause the summary judgment to depose the Eubanks, and you didn't do that.
Yeah, and I didn't think it was necessary in this case, Your Honor, because the circumstantial evidence was clear that they had that knowledge, and not just the driveway. So that's putting aside the driveway. Let's talk about the garage. The garage was absolutely disclosed by them as having this minor issue that was resolved summarily, when the reality was they completely destroyed and upheaved the existing concrete on the garage and then replaced it with these panels. If the standard is to actual knowledge and to knowledge of ever existing, as the contract indicates, that absolutely should have been disclosed. The disclosure that was scant was simply there was a pipe that had leaked. It was addressed without further issue.
But your client's inspection report talked about the panels in the front of the garage and said that they had obviously been put in there to account for expanding soils. Mr. Gastineau,
Yep.
Told your client garage floors in this area are sinking 1 to 2 feet. So he was on notice that this was not only this garage, we had a special floor in there because of a heaving event, which was disclosed, but the whole area was that way. So I'm not understanding what more the sellers could have disclosed about this.
Well, I mean, what you're saying is that the seller can simply disclose that there are potentially expansive soils in the area, and that satisfies their burden of actual knowledge, or to disclose everything ever existing on the property.
Counsel, can I stop you there? Because you come back to this on a number of occasions. As you're answering Judge Freyre's question, can you give us a sense of the daylight you see between actual knowledge and ever existed?
Yeah, I think
how your response indicates ever existed versus actual knowledge.
Okay, so actual knowledge relates to a latent defect condition. That's what ties the mens rea component to the seller's obligation. If there's a latent defect, they have to disclose that based on their actual knowledge. Now, the contract talks about disclosure of anything they know ever existed on the property. Well, that doesn't really limit to that latent defect. That simply expands on the burden of disclosure to say, did something ever exist? If it did, say something. And that's the core
What
problem
if they don't
here.
know, though? Do they have some sort of burden to go out and investigate everything that has ever happened on the property before they owned it to comply with the disclosure requirement?
I'm not even requesting that. I'm requesting that if they knew it, they should have said something. So when it ties to the garage, we knew that took place in 2018 because of the evidence that was submitted in the records. They should have disclosed, not that it was just a minor issue that was corrected as a result of a leak, but they should have said, hey, look, The garage floor had to be completely torn out, not because there was potentially expansive soils in the area, but because those potentially expansive soils had actually become expansive and heaved. And let's be honest about what happened. We had to replace the driveway. We had to replace the garage floor. We had to put jacks underneath the entryway. Those are the types of disclosures that are full, complete, and honest. Not just saying, here is a general analysis that there are potentially expansive soils here. Good luck finding out what happened in the past.
Your inspector specifically highlighted all those areas and then said, ask the sellers for additional information. Did your client do that, ask for additional information?
What my client asked for and relied upon was the disclosures that were produced in the real property transaction. So that my client was entitled to rely upon those exact disclosures without having the burden of full investigation thrust upon him. I think what's really important to consider here is literally thousands and thousands of homes in the Grand Junction, Colorado area are built on, quote, potentially expansive soils. Those are not a big deal because we engineer around them. We put micropylons. We do.
You assert on page 17 of your opening brief that the sellers absolutely knew, but failed to disclose that the soils had activated and caused massive and significant damages.
Yep.
Where in the record do you establish the sellers absolutely knew those facts?
If you look at the seller disclosure forms, you will see that there is a scant disclosure as to these heave events. A heave event, and that term is synonymous with activation of expansive soils.
That may be, but I'm focusing on your language. They absolutely knew.
So what I'm indicating is that if the court reviews the seller's disclosures, there will be a scant disclosure of a, quote, slight heave event. So that is a general admission that they did know about a heave event. They're just underselling it. It wasn't a slight heave event that was caused by a leaking landscaping pipe. It was an issue of activated soils that caused a massive heave event so big that it caused for the complete tear out of the garage floor and replacement with panels to offset the expansive soil issue that they had had. So I think what the court is what I'm imploring on this court is to say, if you knew something, you should have said something. Don't just say enough to make the buyer feel comfortable here. And that's what these disclosures demonstrate. They're these little half-truths that say...
If we reverse and send the case back for a trial, how would you prove what the sellers knew at the trial?
First off, we'll get them on the stand, and we will address their actual knowledge. Second off, I'm going to stand in front of the jury and say, jury, look at the circumstantial evidence. We have shown that there was a driveway in 2016 that was complete flat work, and there was a driveway in 2018 that was made of pavers. You can decide in your own discretion if they knew that that existed based on the testimony and evidence presented to you. Next, we'll turn to the garage. I'll say, jury, you understand that the garage had to be completely torn out. It is your decision based on the testimony and evidence to say, did they know that it was a result of a substantial heave event, and did the disclosures that were produced demonstrate that to the buyer? And finally, as to the entryway, you see that there are jacks. How was Mr. Milan to know that those jacks were not native to construction? Without a full and complete disclosure, he is unaware as to what's happened historically, whether it's original or not original, to the home. And if you see that the disclosure was made sufficiently by the Eubanks, by all means, rule in their favor. But jury, if you see that the circumstantial evidence and direct evidence that's presented demonstrates the opposite, that these are half-truths, that these are not full disclosure, that this is not the disclosure of the actual knowledge or the conditions that ever existed on the property, you should rule in favor of my client. And that's kind of the closing argument, so to speak, as to how the jury can rule. And in a case where you do rely so much on circumstantial evidence, when mens rea is such a big issue.
Can you briefly explain what you view as the obligation that was on your client?
The obligation,
the disclosures that were provided.
Of course, yeah. The obligation on my client was to take and digest the information and decide whether he should rely on it completely, which he does have the right to, and I've cited to many of those cases in Colorado and across the nation where buyers have the right to absolutely rely on the disclosures made by sellers. And secondarily, to investigate additionally. And the question is how far does he have to investigate? Well, he hired an inspector here. He did do some of the things that were necessary to to discover all of the issues. But I think what's missing is he wouldn't have been able to ever discover what actually happened, even on the best of investigations. That took actual admission and actual disclosure. We tore out the garage. We replaced the pavers. We put in jacks. He simply never would have been able to know that without disclosure, even under the best investigation possible.
All right, counsel, your time is up.
Thank you so much.
Thank you.
Good morning, Your Honors, and may it please the court. My name is Ben Wagner, and I'm attorney regulation number 36952, and I'm here today on behalf of the appellees, Sean and Sarah Eubanks. And I kind of want to get into a couple points that Mr. Quigley started off with. He first mentioned that there's sort of kind of two standards on disclosure. So one of the common law of actual knowledge and one of this contractual notion of ever existing. And the contractual document here, just the standard form real estate contract that the state of Colorado uses, talks about that disclosure obligation in 10.2. And what that disclosure obligation says parrots or mirrors the common law, which is you have to disclose a material adverse fact that you actually know about. That's the standard. That's the standard of common law. That's the standard that's put forth in the contract. And here, the Eubanks did that. They provided information disclosures that they actually did know about. They talked about the issues with regard to the garage. They noted the cracking in the entryway. They talked about the heave of the garage. They talked about this drain pipe issue that didn't daylight, that had caused some leaks and caused some issues. And on top of that, they also provided Mr. Milan with the soils report from 2014 that discusses here's the building envelope, here's the building site, here's the soils that are on this site, here's recommendations for the foundation, here's the recommendations on taking care of that foundation, keeping water away from it to make sure that you don't have any issues or problems with it. All of that allowed Mr. Milan to take that information and do what the contract proposes what happens. And that is you take that information, and if you don't like it, you can terminate, you can walk away.
Mr. Wagner, let me push back just a little bit
Sure.
on the actual knowledge. And in the context of a summary judgment motion, I mean, we're pretrial here, obviously.
Sure.
And as counsel points out, we have to draw all reasonable inferences in favor of the non-moving party, in this case, his client. And isn't it at least a fair characterization to say that the disclosure was less than a full embrace of their actual knowledge of the extent of the problem? Maybe I'm overstating a little bit, but isn't that a fair inference that, you know, they just said, yeah, we had this minor problem with the garage, we've corrected it, the crack has since subsided, no movement since that time. Where's that line for us in your mind in terms of a disclosure that is adequate versus a disclosure that is so minimal that it ends up misleading rather than providing an adequate disclosure?
Well, this disclosure wasn't minimal by any means. It did talk about these issues. It did talk about these problems. It did provide the soils report to them and everything there. What Mr. Quigley kind of argued for his client and kind of toning your question, I guess, in my view, you have to be reasonable in your disclosures. And you can't become unreasonably reasonable, if that makes sense. These people are not engineers. They're not home builders. They're pharmacists, actually, in Grand Junction. They don't have this perspective that maybe an engineer would, maybe a contractor would, to say there might be more of a problem. What they know is that they had these issues. They had to take care of them. They addressed them. They paid somebody to do that, and they provided that information to Mr. Milan as part of the disclosure process.
Isn't the issue of reasonableness a classic disputed issue of material fact that can only be resolved through a trial, that can't be adjudicated on summary judgment?
So as part of this case, so you have to, the issue is is what latent defect are they complaining out that we had actual knowledge of that we didn't disclose? And the fact of the matter is that the court found that there was a number of issues that they're complaining about that we did disclose and that he had knowledge of going in and beforehand. What the issue is the big issue, I think, that they're saying we didn't disclose was the driveway issue. And there is no evidence in the record whatsoever that would show that we had any actual knowledge that there was an issue with the driveway. What we know of is that there was a photo out there from May of 2016 prior to my client's ownership of it, and then 2018 that shows a different type of driveway.
What if the photograph had been taken after your clients had purchased the property? Can, under these circumstances, a plaintiff prove actual knowledge by the seller through circumstantial evidence?
Absolutely. And so actual knowledge of that they had actual knowledge of a latent defect. Let's say that photo happened in 2017 and there was a different driveway in 2018. Yes, you can show that hey, you had knowledge that you changed your driveway because you owned that property at the time. That doesn't exist here. Or as part of discovery, hey, did you ever fix the driveway? Send us written discovery asking those questions. Ask for invoices for contractors we hired that went out and fixed this stuff. Send us reports from engineers that you may have hired to come look at the house. All that could have been part of written discovery. All that could have been part of initial disclosures. But the fact of the matter is the Eubanks provided everything that they had. There is no evidence to suggest to the contrary that they knew about this driveway issue. And the fact of the matter is that they met their disclosure obligations because, hey, listen, here's these issues, and we let you know about them. And now under the contract, the real estate contract, that's when the buyer has his obligation. The buyer has to do some due diligence. And there's allowing for home inspections. There's allowing for people to follow up on these issues. The home inspector that went out there identified issues with the driveway, said, hey, there's some heaving or settling. There's trip hazards. There's these issues with no sealant in these areas. There's a bulge in the foundation. And the engineer or the home inspector even suggested to Mr. Milan, you should go out and hire an engineer to go look at these things. And he chose not to do that. So at some point in time, some of this also falls back on him a little bit.
So can I come back to the driveway just for a complete understanding of the record? Does the record reflect whether and when, not whether, but when, your client became involved with the property? In other words, they purchased on December of 2016, but were they working with the builder prior to that time? Were they investigating the property, those kinds of things prior?
No, there's nothing in the record to show that. And what we do know is that the home, I believe it was a kind of a spec home done by a builder vendor in Grand Junction. That home was built in 2014. It was in the Spyglass subdivision, and if you know Grand Junction, a lot of homes in that area have problems, as Mr. Gastineau pointed out, and that home sat for a while before the Eubanks purchased it at the end of 2018.
Was it vacant for the full 2 years?
What's that?
Was it vacant for 2 years?
I believe it was. I believe the builder vendor sold it to them, and they were the first homeowners. I could be wrong, but I believe that was the case. And so when they purchased at the end of the year, that a lot of the work that Mr. Stoll of Knott Laboratory said was done or found to be done could have been long completed by the builder. The fact of the matter is that the record doesn't show that my clients had any actual knowledge of this driveway issue. But there is a picture predating their ownership that suggests that it was changed at some point in time. Why it was changed, we don't necessarily know. That would be a question for the builder. But certainly my clients didn't have any knowledge of that, and that is their obligation. If they knew about it, of course, disclose it. But if you don't know about it, there's no obligation to disclose it. And, there's no sort of guesswork or speculation or conjecture that go into these disclosures, because the obligation is tell us what you actually know about. And that kind of gets back to this notion of these people are sort of lay people, and what an engineer may find as an issue or what a home builder may find as an issue, a pharmacist, a lawyer, or somebody else may not recognized that as an issue. They knew they had some problems. They knew they took care of them. They disclosed that.
I'd like to turn to some of the language in the not laboratory report. So the forensic engineer, after reviewing the property, making some findings regarding the property, stated the seller disclosures indicate that they were aware of the expansive soil. The sellers were also aware of the impact of moisture on the expansive soil by their efforts to locate moisture and correct these issues. Doesn't that portion of the not report create a disputed issue of fact as to what the sellers knew?
No, because that's exactly what's in the disclosures. And you can reread that again, but I'll show, but they knew about the expansive soils. True, environmental conditions on the disclosures, they say, see soils report, house is built on expansive soil, house built on micropylons per geotechnical engineering recommendations. They knew about water causing issues. True. They talk about the cracking that appeared and the heaving in the garage due to the drainage issue. They specifically state there's slight heaving in the garage floor due to moisture drainage issue with pipe not being daylighted prior to landscaping. These were since replaced and daylighted apparently. What Mr. Stoll is saying is exactly what the disclosure says, is that they knew that there was expansive soils and that they knew that there was a prior problem with some water that caused some issues. Unless I missed something that you said.
Well, the report also says it is assumed that the adjustable steel jacks were installed by the previous homeowners in an attempt to mitigate the differential foundation movement. And then it goes on to say the installation of these jacks was not disclosed. Does that create a disputed issue of material fact?
No. And the reason for that is they did talk about the entryway, and there is no evidence in the record to say that these guys installed that jack, and they might not have known about it. This could have been done as part of the garage work and something like that, and a contractor put that in as part of the repair work. You know, what you're saying is what a contractor may have done to repair something, you know, unless these guys are sitting there watching their every move and exactly what they're doing, you know, how are they supposed to know about that? What they did say is, we've had this issue, this was done, and then under the contract, the real estate contract, it becomes an obligation of the buyer to get a home inspection. And all this stuff was pointed out in that home inspection that could allow for further investigation by Mr. Milan before he ever pulled the trigger and purchased this home. The fact of the matter is that the real estate contract says, Mr. Milan, you're purchasing this property as is, where is, and with all faults. And because we're doing that, we're going to make the sellers provide you with their actual knowledge of all latent defects. And they did that. And then the real estate contract provides termination for things he doesn't like, allows for inspections to be done. So he has open eyes going into the transaction and knows what he's getting into. The fact of the matter is that he was told of all this from numerous people. Mr. Gastineau, his home inspector, the original engineer that provided the soils report, and even the disclosures by the Eubanks themselves, which would have left him to say he had enough information to decide, do I want to take this risk on or not? And furthermore, what he was recommended to do by his home inspector, he didn't do until he filed litigation, which is actually get a not laboratory or an engineer out there to take a look at this a little bit more closer. His home inspector recommended he actually do that before he purchased this home.
Counsel, I have a question on the actual knowledge. When the Eubankses purchased this home from the developer, obviously the developer had to do its own disclosure of all the things that had happened. So they had actual knowledge of whatever was in that document at the time they purchased that home. Would that actual knowledge back in 2016, is that something that should have been incorporated into this disclosure report?
Are you saying that the disclosures that they may have been provided as part of that process,
Yes.
should that have been given to Mr. Milan in this case?
Yes, or should that be imputed, whatever was in there? I know we don't have evidence in the record, so this is hypothetical, but
Right.
If all of these things that are coming out in the not report, if it said, yeah, we replaced the driveway this time, all this stuff happened, would that establish their actual knowledge and a failure then to disclose in the in their disclosures?
That's a good question, and I don't know if I have a good answer for it, because what the builder may know and what the builder describes may not necessarily comport into actual knowledge for somebody else. You know what I mean? I mean, somebody can tell you something that might not trigger anything. What the contract does say is that you got to describe what you have actual knowledge of, and whether the builder disclosed some of the stuff that they knew about isn't in the record, and I don't think anybody knows that. But what we do know is these guys said, "Hey, here's what we know about," and that led into some further investigation that was done by Mr. Milan, and it just stopped. And it appears that now Mr. Milan's then happy with what's going on because he's got to do some maintenance and he wants to get out of it. But the fact of the matter is that he had a lot of information to provide to him that would say either you should walk away or you shouldn't. And he decided to go in, and I guess I'm out of time, but we'd ask that the summary judgment order be upheld.
Thank you, counsel.
Thank you.
No, you went over your time. Thank you both, counsel, for your arguments. They're very helpful. The case will stand submitted and an opinion will issue in due course. And we will take up our last case once counsel have had a chance to get set up at the table. All right, I will call the case of People in Interest of SM, case number 23CA1674. I just would remind both counsel not to use names in this case. You will be responsible for monitoring your own time. Do you have any questions? All right, you can proceed. Thank you.
May it please the court, Josie Burt, attorney registration number 50046 on behalf of minor child SAM. It is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law, wherever that right is invaded. For it is settled and an invariable principle that every right, when withheld, must have a remedy, and every injury its proper redress. I don't mean to give you nightmares of law school by quoting Marbury versus Madison, but Chief Justice Marshall is right. The very essence of civil liberty certainly consists of the right for every individual to claim the protections of the laws whenever he receives an injury. SAM's case, at its core, is ensuring that her rights are protected even though she's a child. She still has the right to healthy familial relationships and a safe home environment. She still has the right to proper care and guidance to serve her best interests. She still has the right to preserve and strengthen her family ties, including the improvement of her home environment, as stated by the General Assembly.
I have some questions about the court's findings.
Yes.
The court found that the child was not in an injurious environment. The court found that father didn't mistreat or sexually abuse her. The court found that mother had not coached the child. The court found that the child could not say with certainty whether she'd been sexually abused. And the court found that the therapist could not identify the source of the child's trauma. Are we bound by these findings? Don't they have some support in the record?
I think that our standard of review here is that mixed review of law and fact. I certainly think that for the findings that the court made that have evidence in the record, I think we can accept those. But I think the issue really goes back to not whether there's a sufficiency of evidence to find that an adjudication should occur, which I think there is. I think reading as a whole, I think there is. But that the court in permissibly required fault for the injurious environment finding and for the no fault finding. If you read the court's orders as a whole, what it says is that one of the things you said is the therapist can't find the source of the trauma that this child has endured. But in that saying that the child has endured trauma, the child has played these themes of safety and protective and has acted out in a sexually aggressive way in therapy. And I don't know any therapist that's going to say this is where the trauma is from.
Well, let's turn to the specific finding that child was not in an injurious environment. Wasn't there some evidence on the record that supported the court's finding?
I think that the evidence in the record supports that the child was in an injurious environment as a whole. I think if you look at some of the other findings that the court made when it made that finding, including stuff that father put in his brief, like that mother and her boyfriend fought often, which SAM witnessed. Mother had to call the police several times. Mother didn't believe the doctor's diagnosis of a UTI and that she pursued these sexual assault claims. I think whether or not the sexual assault occurred, I think the court's findings on that are clear and are supported in the record. The court can't find by preponderance of the evidence a sexual assault occurred. Okay, but SAM still believes that a sexual assault occurred. She's still telling everybody who will listen that a sexual assault occurred or is continuing to occur. And so that is the injurious environment that the child is in, where her parents have created this animosity between each other, where mom is making these allegations towards dad about the broken arm, and it's not really true, and calling in the department, and all of those things are above and beyond a typical high conflict divorce case. This is no longer about custody.
Are you asking us to make our own findings and to override the juvenile court's findings, to find that mother did coach the child when the juvenile court said mother hadn't, that father had mistreated or sexually abused the child when the court's finding was to the contrary? Are you asking us to, in effect, second guess the juvenile court?
I mean, I would love for that to happen, but that's not really what I'm asking for. What I'm asking for is for this court to remand this case back to the juvenile court and say, you need to use the law as it states, which is that an injurious environment does not require the fault of the parent. It does not require a finding of sexual abuse. It doesn't require a finding that the child is coached or not. What it requires is to look at what is in the best interest of the child and whether or not that environment is injurious to their welfare.
But counsel, isn't all the things you've just listed part of that consideration? I don't know how you can consider an injurious environment without considering the actions of all the people that are interacting with the child.
I think you consider those, but I think you also consider what the court said was the best testimony that it had, which was that of the therapist that is saying that this child has undergone trauma, is traumatized, and has a diagnosis of PTSD. This doesn't come from a...
Don't all kids who experience divorced parents experience trauma? I mean, and courts deal with... Domestic courts, anyways, deal with parental alienation all the time and deal with families in therapy. I don't see what the distinction is between trauma and that a domestic court could deal with in an injurious environment that requires the intervention of the government into this family's life. Just because the child is traumatized does not necessarily mean that the child needs to be adjudicated dependent and neglected.
So to answer the question that you first asked, I'm not a therapist, but I will say every child I see is traumatized. But I work in dependency and neglect law. Is every child who undergoes a divorce traumatized? I don't know. But I do know that there were two cases that go directly to your point about where the line is between a domestic relations case and a dependency and neglect case. And those two cases are the two cases that are Kearney versus Blue and Cura versus Kelly. And both of them state in various language that there is a fundamental difference between a dispute between parents in custody and a JV court. And if it is a concern of custody between the parents, then the JV court doesn't have jurisdiction and the case should be dismissed. The Carrera Court holds it is a true and unmistakable sense this case presents a question of the right of custody and does not justify adjudicating one's dependency. Here, it couldn't be further from a custody dispute. The DR court was there. It had been used to alter custody. But when mother was unable to use the DR court to keep SAM safe, the department got involved. And mother freely admitted that this environment was injurious to SAM's welfare. And SAM continued after that point to make disclosures and to have these behaviors that we look at in children to determine whether or not their environment is injurious. We look at the mother testified to the child cutting her hair and putting nail polish on the carpet and drawing on the walls and the furniture. The school therapist testified that when she came back from school in January of 2023, that her behavior was different than that it had been the previous year.
Counsel, assuming all that's true, and to your argument about it was improper to look at fault, don't we have an alternative explanation, or at least a potential alternative explanation for some of the factual findings that you think were supported? So, for example, let's assume that there was lots of evidence that the child is under duress and under stress and acting out in the manners and manifesting stress. Mom was also in a relationship with a man, and there was at least some evidentiary suggestion that that person may have been responsible for this sexual assault. And so the child could be experiencing all of that. The child could be experiencing communications with mom where she feels like she's being coached and or it looks like she is, dad's accusing, but mom may legitimately be saying, here's how we need to deal with this issue of abuse. So isn't there an explanation, I guess is my point, that is independent of a finding that either parent was at fault, that this child has some traumatic incident? The evidence wasn't sufficient to prove it was either mom or dad. Child is just simply in a stressful environment. In that situation, where there's no fault shown for the parent, to either parent, are you suggesting that we should sanction an adjudication of the child as dependent or neglected as to one or both of the parents under that circumstance?
Yes, because that's what the General Assembly has set out in their including that language. There's a case that says that it's the JG case that says paragraph C differs in two ways from the others in the statute. One is it doesn't include parent, guardian, or legal custodian in its language. We don't need that in order to find that the child is in an injurious environment. And the JG case says that the General Assembly's intent is to focus on the existence of the injurious environment rather than on who caused it. So I don't think we have to look for the parent to cause the injurious environment. This injurious environment exists. This child is in this injurious environment.
I'd like to follow up on that point and to follow up on the point that Judge Schutz made. Didn't the record evidence show the child was doing better once boyfriend was no longer in the picture? Once he had moved out, once boyfriend's relationship with mother had been terminated?
Yes, and certainly that's the argument that is made by father in his answer brief. I don't know that that is enough to say that this child is not in an injurious environment because, again, you're trying to ascribe fault to the boyfriend and then saying, well, now the boyfriend's gone, so the injurious environment is gone.
But
we don't know.
Doesn't that provide record support for the court's finding that the child was no longer in an injurious environment?
I think it provides record support for saying that the child was doing better at the time that this case had its adjudicatory hearing and moving forward into today. I think looking at the totality of the evidence, including that, I think using the court's findings, I think the court could still find that this child is in an injurious environment, or alternatively, the other one that we haven't talked about is that the child was not domiciled with father through no fault of his own, which is pretty clear. The child was removed from his care. And whether or not in that case, we don't have to ascribe fault to him either. We can say it's 100% mom's fault that the child is not domiciled with him.
And isn't that the situation? It's been a while since I looked at JG, but my memory is that that's the situation in JG, that it's a non-custodial parent where there's a finding of no fault. The injurious environment exists with the custodial parent. And in that context, the non-custodial parent can be adjudicated, or the child can be adjudicated as to that non-custodial parent without fault to that parent. But are you aware of a case that has said where there's a factual basis to conclude that neither parent is at fault for the harm that the child is experiencing or the stress, that we have the authority to enter an adjudication, or the juvenile court does, to adjudicate a child dependent and neglected?
I will say that JG only focused on the injurious environment statute. The case that focused on the no fault was MSV People, and that was with a disabled child, where it said neither parent is really at fault for this cause that this child is disabled and that they can't take care of them, but we're focusing on the best interest of the child that determines the care that they should receive. I think more importantly is that the MM case, which was a motion for summary judgment case where dad said, yeah, I agree, mom's environment is injurious to her welfare. The court said these statements were effectively an admission that the children were in an injurious environment. I think that's the same case here. Dad certainly can look at mom and say, all of these things are wrong with mom. The child is with mom, and it's not my fault that she's not with me because mom has made these false allegations. But that situation where the child is in with the high tension between the two parents and they're in a relationship, that is an injurious environment to her, or no fault of dad that the child isn't with her. And
let's say we reverse. We send it back. The court determines that the child is dependent or neglected. It goes down the line, months pass, maybe years pass, and the parents don't comply with treatment plans. Is there any case law supporting termination of parental rights where there's no evidence that the parents' actions or failures to act resulted in the child's injurious environment?
193604 requires an adjudication in order to get to termination. And so I don't think that there's any case law that really differentiates the difference between the types of adjudication, because all it requires is an adjudication. I'm requesting this court find that the order is final and appealable order because it dismissed the entire case, and to remand this case back to the trial court for findings in accordance with the proper law, not requiring fault. Thank you.
Thank you, counsel.
Good morning, Your Honors. My name is Paige Mackey-Murray, attorney number 29887, and I represent the father, the appellee. Regarding the merits of the case, standard of review is critical here. This trial court was in the position to determine the facts, to determine the credibility of the witnesses, to determine the indicia of reliability of the child's statements, and it was the trial court that gets to decide whether or not the child is in an injurious environment. There really is no question of law here at all. The question of whether or not the court is to look at the fault of the parents is kind of a distraction here, because the people did not meet their burden of proof by a preponderance of the evidence that either parent was at fault. And this court, absent clear error or a complete absence of evidence, can't really address that argument. The statute provides for two tiers of analysis. The first tier is the people have to prove their allegations by a preponderance of the evidence. The second tier is if the people have proved to those allegations, then the court has to determine whether the child meets one of their criteria for dependency and neglect, one of which is injurious environment. And that also is a factual question. There are legal parameters around how those criteria are interpreted, but it's ultimately a factual question whether this child is in an injurious environment. So putting aside the people did not prove that father sexually abused the child or that mother coached the child, and So all that's left really is these statements made by the child, which the trial court had the ability to determine how reliable they were, and some other tangential evidence regarding that something might have happened to this child. And what the GAL is trying to do is say this court has to rule as a matter of law that when you have that situation, there must be a finding of dependency and neglect. And that would be inappropriate for this court to do. That's a factual determination. And there's no support for that kind of rule of law in the statutes or the precedent. And what it does is it removes the burden of proof from the people. It deprives parents of due process. It improperly injects the government into their lives and into their families without the people having to prove up their allegations. There could be simply an accusation of abuse, and suddenly we have to find that there's a dependency and neglect. And that would be inappropriate under the statutory framework and under the due process requirements, essentially. A couple things. She mentioned domicile as an alternative grounds, but that wasn't raised by the prosecution or by the people as one of the grounds for finding an injury or for finding a dependency and neglect. This really is a simple case in that regard because the standard of review is critical. It's an issue of fact, and this court really can't overturn that without finding that there's a lack of evidence. And there was ample evidence here to call into doubt whether father sexually abused the child or whether mother coached. Now, the issue of the boyfriend is important. It's an alternative plausible explanation for some of the behaviors that have occurred. She couldn't find, the court couldn't find that he was a perpetrator of abuse as a matter of fact, and he's no longer with the family. And the people did not pursue that because he was no longer in the picture. It wasn't part of their allegations. But it is a plausible alternative. It casts doubt on the accusations by the people. And so it supports this idea that this factual conclusion by the trial court that this child was not in an injurious environment.
As I understand the guardian's argument, I think she is saying that, look, there wasn't a finding that the child's not suffering. And the child appears by the undisputed evidence to be suffering in some fashion. And that should be deemed reflective of her being in an injurious environment or otherwise in need of intervention from the court. What's the fault in that analysis, if any?
Well, I think primarily the fault in that analysis is that determination about whether or not the child's in an injurious environment based on what facts were proven is in the trial court's purview. It's what the trial court is supposed to do as a factual matter to make that determination. So maybe there's evidence to coming out the other way, but that's not the question on appeal. The question on appeal is, did the court have to come out the other way? Was it error for the court to make the factual findings that it did on injurious environment?
But I think counsel's argument is, look, I'm not taking issue. There's factual support for the finding that mother wasn't coaching. There's factual support for the finding that father did not sexually abuse. But there's no factual support to conclude that this child is not suffering at some level. And so from that suffering, as I understand the argument, counsel is arguing that we should conclude that that is a factual and legal basis for adjudicating the child dependent or neglected. So where's the flaw in that analysis?
But there's some evidence to show that even if the child is suffering, it's not due to the injurious environment, right? It's due to perhaps this other person's involvement. So there's other evidence that supports the finding that it's not the injurious environment that's causing the suffering. And I think at some point it's up to the trial court to make a decision, well, what kind of evidence rises to the level of injurious environment so that the government has an ability to intrude on the family's life and say, we're going to inject into this family our supervision. And so there's an element of that as well. Just like Judge Favre said, there are children in trauma all the time. Not every case of trauma is an instance of dependency and neglect, especially where there's evidence here that the cause of the trauma might be gone. So it comes back to the standard of review. In a lot of ways, this is a really simple case on appeal because it comes down to factual determinations by the trial court.
But as a matter of logic, based on the record, based on the testimony that the court heard, did the court err by finding both that father didn't sexually assault the child and that mother had not coached the child? And I note the testimony of the school counselor who said that the child had made a disclosure she was being touched sexually by her father. The intake caseworker said the child had made outcries, had expressed fear of father. The therapist had said that the child had disclosed sexual abuse by father. The forensic interviewer said the child disclosed sexual abuse by father. Doesn't that evidence show either that father sexually abused the child or that mother had coached the child to make those statements? And if so, doesn't that establish injurious environment?
Well, I don't know that as a matter of law, coaching, even if it were established, would automatically cause an injurious environment. I don't think we have case law out there that says that as a matter of law, that's necessarily an injurious environment. But here, there's evidence that even if she was saying something that wasn't true, it's not necessarily the case that she was coached by a mother. There wasn't direct evidence of coaching. And what is coaching? We have to talk about what the definition of that is. It hasn't been flushed out factually. This ended up being kind of an alternate grounds as the evidence came out. But, I mean, it could have been Jennings that was coaching, right? It could have been the boyfriend that was involved in, I mean, it's just a plausible alternative because he was part of the chain of reporting. And he was one of the people that suspected foul play even and said that and took her to the doctor before there was ever an outcry. So it might not have been mother that did the coaching. I mean, we just don't know. The evidence just isn't there to solidly say that mother coached. And again, within the realm of the trial court's purview to say not enough evidence here by a preponderance of the evidence for me to find that mother coached. So with that two-level of analysis, I think the bottom line is that this is an issue of fact that needs to be needs to be affirmed on appeal. I did want to take just a second to talk about the finality question. I know it hasn't arose yet, or hasn't arisen yet. There's a couple things I just wanted to say about that. One is the policy issues that limit the people's ability to bring appeals in criminal cases kind of mirror some of the issues here. Because what we have is the power of the state involving themselves in family lives, involving themselves in these cases.
But we don't have double jeopardy. I mean,
Correct.
if the department wants to bring another case, they can do it. If they think this child is still in an injurious environment, they just need to file another petition, right?
Absolutely.
Okay.
That's right.
I'm sorry to interrupt.
Sure. No, I agree with that. And I think, but this allows, if we allow the people to bring these kinds of appeals, this is a perfect example of it. We have a pretty clean case that's dealing with factual issues, but we're dragging this out. We're making this party have the involvement of the state and involvement of the case in appeal for an extended period. It might even end up in the Supreme Court, right?
Didn't RS address this issue, though? And aren't we bound by the Supreme Court's ruling in RS? And in RS, the court granted cert to address the issue whether a denial of adjudication in a dependency and neglect action is a final order for purposes of appeal. The Supreme Court said yes. There was a one justice separate opinion, which of course we can't follow. Justice Coates didn't speak for anyone but himself. Aren't we bound by what the court held in RS, and therefore aren't we bound to determine that there was a final appealable order here?
And you may be. There is some argument that specific discussion in RS was not necessary to the holding, and therefore it's not binding precedent. So we have the majority and the concurrence, and they're both not binding. We could revisit that. We could push it and get it up into the Supreme Court and have those arguments again.
Is it your argument that all of RS is dicta?
No, not all of RS is dicta. I think the ultimate holding that actually dictated the outcome is not dicta, but perhaps the majority.
But that holding was premised on the existence of a final appealable order.
It was, but for different grounds than what we have here, because there was an adjudication remaining in that case that isn't remaining here, because everything's been dismissed here. So it's a little bit different.
And isn't that the definition of a final order? Everything's dismissed, there's nothing left to do, that seems to me to also kind of define finality.
Yes, it is. And it comes down to that statutory interpretation, which Judge Freire, I know you're very well versed in, having written SML. And it just comes down to whether that statutory interpretation makes sense and whether the Section B and C were intended to carve out exceptions or whether they were intended to outline the realm of what's appealable.
What's left to adjudicate here?
Excuse me?
What's left to adjudicate here?
In what regard?
Hasn't the case been completely resolved?
Oh, yes. Yes, it has. Yes, so in that regard, it's final. And the question is whether, nevertheless, a case like this shouldn't be brought by the people. And that's what goes to that policy question. Just real quick, I wanted to address on the same grounds, on the same line of thinking, the GAL's reply brief. And one of the things she says is that as a GAL, she might have more power to appeal than the people might. And I think that's an expansion of the concurrence's language that isn't warranted by the language in the statute. There's no distinction really in the statute between whether it's the people appealing or the juvenile appealing. So I just wanted to address that since it was in the reply brief. We asked this court to affirm the lower court's denial of the adjudication and let our client move on and heal his family. Thank you very much.
Thank you, counsel. Thank you to both counsel for your very helpful and excellent arguments. The case will stand submitted and an opinion will issue in due course. That concludes our docket for Division 6 for today. The court will stand in recess and the bailiff may call.
All rise. The court will be in recess.